Hi, I'm Tom Wilson. I'm the founder of Wilson Law Office. And the topic for our video today is myths about domestic battery cases. Now, before we go into those myths, I want to say one thing first. Every one of these domestic battery cases creates a lot of risk for you if you're facing the charge. And there's a lot of ability to fight these cases because typically there's not videotapes or other information like that. So it's important to get representation right away. And I would encourage you to call the number below to our office to schedule an appointment so we can sit down and talk about your case and discuss how we can help you through this process. And now let's take a look at some of the myths around domestic batteries, because there's a lot. And there's a lot of things people talk about in these cases that aren't necessarily true. So the first one that comes up, and I see this, I was talking to a prosecutor recently, and she estimated that at least 60% of the cases, domestic battery cases, this happens in, and that is there's a complaint filed with the police and the alleged victim then recants and says the battery never happened. It happens all the time. And a lot of people believe that that automatically means that the state has to dismiss the case. That's not necessarily true. Now, the state can't always move forward if the victim changes her story. It depends on all the evidence. And the only way you can find that out is if you either have a thorough understanding of the rules of evidence, or if you talk to a qualified criminal defense attorney who has the experience to understand when her previous statements might be admissible and when they're not. So those are things you need to get help with in that situation. On the flip side of that story is when you have an alleged victim who claims and sticks to her story that she was beaten or hit or kicked or whatever might have been done, and she stays with that story, but there's no evidence of injury. There's no bruising, there's no broken bones, there's no cut lip or anything that indicates that something happened, or even a broken chair or whatever might be evidence to show it. And sometimes people believe that a lack of that external or other evidence is enough automatically to have the case dismissed. And what you need to understand is that when you go to court, evidence most commonly takes the form of testimony. You will see videos in court, you will see pictures or other documents like that, but evidence includes testimony. So if a person says that there was a domestic relation and there was unconsenting touching in a rude, insolent, or angry manner that resulted in physical pain, that's a domestic battery as a misdemeanor and in Indiana. And that case can move forward to a jury based on that testimony. So it's a myth to believe that just because there's no evidence it has to be dismissed. Now that doesn't mean that it can't be fought. It doesn't mean that it's a strong case for the state necessarily. Every case depends on all the facts that are there, and you need to look at it, but that's what you need a qualified criminal defense attorney to represent you for, is to find those things out and use them. Another very important thing that people get confused about, and this is no contact orders or protective orders. Many times people believe that if there's a no contact order or a protective order, that means that neither side can have communication. And so if the alleged victim reaches out and says, hey, let's talk, if the person who has a no contact order against them, they're now free to talk. And that's not true. The no contact order, unless there's a separate one entered for the alleged victim, the no contact order only applies to one person. And the one thing that I've seen is that there is judges in Elkhart and in St. Joe County and in northern Indiana will, more than any other reason, send you to jail right away for violating the terms of your bond if you have a violation of a no contact or protective order. It doesn't happen every time, but it happens far more often than anything else you can do. Do not have contact with the person protected by a no contact or protective order. The last thing is not so much a myth, but I want you to be aware of this, and that is if you have a domestic violence conviction on your record, your right to possess a handgun will be lost, and while it can eventually be reinstated if you criminal charges for that as well. So those are some things that are important for you to be aware of in the domestic violence context. I hope this video has been helpful to you. If it has, call the number below, schedule a time for us to talk to see if we can help you through this process. I'm Tom Wilson, founder of Wilson Law Office. Thanks.